our kai kōrero i te kai waka imi e Kiri. Tō kaha ki te kawe i ngā kaupapa o ngā hapu o ngā iwi. We acknowledge you, Kiri, and that you carry a legacy of legal work, of mahi that you do in intellectual property rights for over a decade, supporting Indigenous people throughout the world of intellectual property, and also for the World Intellectual Property Organisation. Your focus this afternoon is to provide a summary of Y262 claim, and so we acknowledge all of the generations, past, present and future, which form part of Y262. Ka tuku te kōrero, te rākau kōrero ki a koe. So without any further ado, I hand to you the rākau kōrero, the talking stick. Ngā mihi ki a koe, tēnā koe.
Kia ora, tēnā koutou katoa, ko Hiriki mata te maunga, ko te mono nui o toi te moana, ko Aotea te mautiri rongonui, ko Kiri Toki tōku ingoa, hiuri ahau no Ngāti Rehua, Ngāti Wai, no te motu o Aotea. So thank you, Hinerangi, for that lovely introduction. And thank you so much as well to the organisers of this incredible hui. My goodness, right from the start, it was captivating and inspiring. So it's thank you so much for organising this hui and also for asking me to be a small part of it. I'd like to acknowledge the hard work of the Kaimahi, the organisers, and as well to acknowledge the other speakers that we've heard from today. It's been truly incredible. So I'm going to try and share my screen. Hopefully I do this right. I think that's it, kapai. All right, I'll make it larger. So yeah, so my name is Kiri, and I've been asked to speak about the Y262 claim and the Tiaki Taonga solution that's essentially come up as a result of the hard work of the claim. As we all know, this hui has been about the weaving together of different Indigenous feminine voices, and it's been against the backdrop of this Y262 claim and the Tiaki Taonga solution. So it's my privilege to speak a little bit more about the claim for those of you who don't know. I will start though with, I guess, two sort of caveats. The first, well, not caveats, more sort of acknowledgements. The first is that I consider myself a mokopuna of this claim. So thank you, Hinerangi, for acknowledging those in the past that began the claim, that have worked on this claim tirelessly. It is an old claim. So my role in the claim is very, very recent. From a young age, I remember going to lots of different hui with my grandfather and whaia Thelma. So that's my small role in this mahi. And I'd also like to acknowledge the sheer scale of this claim. It is large. We'll talk about it shortly. That in my mind, it's quite a simple claim, but it touches on many different issues. So I'll do my best to sort of distill it to its key attributes. So for my kōrero today, it's quite simple. I just want to discuss what the Y262 claim is in a very sort of simple way. And then I want to touch on basically the solutions that have come up or that have been discussed. So I'll touch on the Waitangi Tribunal report itself, discuss what it said that was helpful, and then discuss some of the problems with the report, and then introduce the Tiaki Taonga solution or model, which is really, really exciting. So dealing with the first of those questions or those issues, that the Y262 claim, to truly understand the claim, I think we need to take a step back and acknowledge a problem that many Indigenous peoples are familiar with and have encountered for a long, long time, and that we all continue to face even today. And that problem is that essentially traditional knowledge, Indigenous traditional knowledge, can be freely used without Indigenous people's permission, consent, or authority. So this is a simple way of explaining a huge problem that we all face. And a part of that problem is that our traditional knowledge can be used offensively as well. Without us, there are some ways to prevent that from happening, but they're incredibly limited. So this problem comes up in many, many different ways. It can come up in research, the commercialization of our plant species, our knowledge in those areas. And in Aotearoa, New Zealand, I'm going to just discuss two sort of examples where we can see the use of our culture in ways that we don't necessarily agree with. So this first example, it's an ad. This is an example of the use of Māori culture and in a way that's offensive. We have the Māori culture, some kind of warrior wearing traditional dress, riding a kiwi. None of those things, none of that depiction is in any way respects the mana of those things. It's quite derogatory. But the ad itself is also for alcohol, which especially for our brothers and sisters in the US, they're no strangers to, and the use of alcohol paired with Indigenous culture is offensive. Another more recent example here in Aotearoa, this is an example of how our culture is commercialized without our permission. So here we have some dolls wearing Māori traditional dress. None of these products were authorized by Māori, and none of the profits that have been gained out of selling these dolls, these toys, have been shared with Māori either. So here we see, again, not just the commercialization of our culture, but the exploitation of our culture too. So this is the problem, I think, that many Indigenous peoples know and we encounter on a daily basis. So against that backdrop, what the Y262 claim is essentially, it's a response to this problem. It's an attempt that was made by Māori here in New Zealand to essentially reclaim control over the use and the exploitation of our traditional knowledge. So it was filed in 1991, which is a long time ago by most sort of standards here in New Zealand. And it was filed by 5 incredibly forward-thinking individuals. And luckily they had the expertise of the indomitable Moana Jackson. He was the initial lawyer for the filing of the claim. And for those of you who haven't read that filing, you should. It reads beautifully in the very Moana way that he would always draft things. So it was a claim filed in the Waitangi Tribunal, and it was essentially to seek control, Māori control over our Taonga and our mātauranga Māori, or for sort of a more international way of framing this, our traditional knowledge. It's known as the Flora and Fauna claim, but it truly is huge in what it attempts to cover. So it's known as one of the first all-of-government claims, and what that means is that because the claim deals with something that touches on, for example, intellectual property, it touches on the protection of our language, it touches on the DOC estate, so that, that's the Department of Conservation here in New Zealand, and the lands that they control, the permissions that DOC will grant to certain researchers to access taonga or plant species or animals that might be kaitiaki of ours. It touches a whole host of different government departments. And so because of that, it triggered this all-of-government reference. And to me, it's always incredibly surprising, because at the heart of the Y262 claim, it's very, very simple. It's all about Māori control, tino rangatiratanga, over our taonga. That's not a hard claim to understand, and yet it triggers all these different sort of iterations throughout the government. And that's why this claim, although known as the Flora and Fauna claim, is one of the most complex claims ever filed in the tribunal. It was one of the longest in terms of the hearings that were run by the tribunal. And I think quite interestingly as well, it was one of the first contemporary tribunal claims filed as well. So the claim itself isn't historical exclusively in its focus, although that's definitely part of it. The claim actually deals with how the Crown, our New Zealand government, is going to deal with these issues in the here and now. So that was also something quite noteworthy about the actual claim itself. And I thought, considering the forum that we're in, it would be appropriate to just touch on the the actual 5 named claimants of the Y262 report, and specifically talk about 2 of those claimants. So 2 of the claimants were women, and you can see their picture on screen now. That's Whaesana Waitai Murray and Auntie Thelma Wihongi. These 2 women, I think it's incredibly appropriate to both acknowledge their role, but also to speak to their role in this forum. The first reason, of course, is because, and this is not stretching the boat out at all, they were the genesis and they were the carriers of the Y262 claim. That's well established. The second reason why I think it's really important to acknowledge them is that, to me at least, they speak to the beautiful relationship that women, Indigenous women, have with our culture and with our traditional knowledge. So these 2 women from the north, Ngāti Kiri and Te Raroa, they were incredibly knowledgeable in their cultural practices, whether it was harakeke and weaving or kumara, whakapapa, storytelling, and they could see at the ground level in their role as women within their whānau and their hapu, that there were issues taking place with regards to our traditional knowledge, that it was being diminished, it was being used without our permission often. And instead of just sitting by and watching that happen, they chose not only to take action, but incredibly creative action at that time. They filed a Waitangi Tribunal claim, and basically the products of which I'll talk about shortly. So I'd just like to, I think it's no coincidence in my mind that this claim was birthed by women, cared for by women, carried by women, and they remain at the forefront of the claim to this day. So just a huge mihi to both of these women. And the wonderful thing about this as well is that their legacy continues today. So we have Sheridan Waitai, that's Sana Murray's mokopuna. She's a huge part of the continued work in this space. And then, of course, we have Auntie Hema Wihongi, who is Dao Wihongi's daughter. And she needs no introduction. All I can really say and sort of add to all the other speakers that have spoken about her is that we are in incredibly safe hands at the moment with her at the forefront of the claim today anyway. So that's the Y262 claim itself. The tribunal came out with its report in 2011, and I like to think of the tribunal's report as a first response to the Waitangi Tribunal claim. It's a huge report, literally like 3 volumes as thick as this. It's an incredibly detailed report, and I think the tribunal did do a really good job. It's really helpful from a Māori perspective because it found that there should be no offensive use of our traditional knowledge or mātauranga. It also found that Māori are entitled to reasonable control over their mātauranga, that there are different standards of engagement from us owning our taonga all the way down to us being consulted on the use of taonga. And they also said that while there's no right of ownership in some instances, the kaitiaki relationship with mātauranga should be protected. So that's quite a creative addition that the Waitangi Tribunal recognised here. And sadly, the report still in 2024 hasn't been implemented. Unfortunately, though, the report is slightly problematic, particularly from the initial claimant's sort of perspective. Firstly, it's problematic because it acknowledges that there sometimes will not be rights of ownership, Māori rights of ownership to our taonga or our traditional knowledge. And this is not only contrary, I think, to tikanga, but also to international standards. So they have said that the Treaty of Waitangi does not provide for exclusive ownership of mātauranga Māori. And this comes up quite a few times in the report, which is problematic. Another area of concern is that they recognise that protection, while it can be afforded, will be limited. So it's limited only where the circumstances justify it. And where it is justified, the protection is only to a reasonable degree of protection. So those are incredibly qualified and problematic. Equally, the report itself and its recommendations only apply to commercial use of our knowledge or our traditional knowledge. So what that means is anyone who uses it privately isn't captured by these recommendations. Privately, people can still use our taonga, our mātauranga, however they want, offensively, whatever. So that's an issue. Another is that it applies only to things or works that are created in the future. So things that were already created beforehand are sort of immune. They're not sort of captured by the report. And I think also problematically that the report only applies to mātauranga Māori that's closely held. So it doesn't apply to works that are inspired by our culture. And finally, the report's very pragmatic, which is good in some respects, but it fails to truly address the constitutional elements of the claim, which are significant. So against the problems of the report, as helpful as it can be, a wonderful new solution has been developed called Te Aki Taonga, the Te Aki Taonga model. So this has been spearheaded and championed by and developed by Te Taumata Whakapumo. So this rōpū, for those of you who don't know, these are the whānau and the iwi representatives of those 5 incredibly forward-thinking individuals that filed the claim. And they basically hold the mana and the vision of the claimants and their sort of initial objectives that when it was filed all the way back in 1991. And so they have developed Te Aki Taonga, and in my opinion, it's incredibly elegant and simple in the way that it operates. Very simply, because I know that I've got only a short amount of time, it's comprised of 2 limbs. It's a standalone framework. So what that means is that it operates in every single instance where the use of mātauranga Māori or taonga might be an issue. It's comprised of 2 limbs, as I mentioned. So sui generis legislation on the one hand, that's just a flash Latin phrase to say specialised legislation, so an act of parliament. And that will be supported by soft law solutions, things like codes of conduct, contractual provisions, educational material, and that sort of thing. So it's really simple because it essentially recognises te tino rangatiratanga of Māori over our taonga. And so for those of you, if you're interested, I highly encourage you to visit the website teakitaonga.com, and this is a little screenshot of what it looks like. And just briefly before my time runs out, I think I'd just like to speak to some of the key pauura and the principles and the features of Te Aki Taonga. So unlike the Waitangi Tribunal's report, Te Tino Rangatiratanga is the heart of Te Aki Taonga. It recognises basically that the kaitiaki of Taonga, whether that's a whānau, a hapu or an iwi, will be the decision makers. They will have exclusive decision-making power over their taonga. It also recognises that Māori, the Māori of Taonga, is a value in its own right, as well as the whakapapa of Taonga. So both the whakapapa of the Taonga itself, as well as the whakapapa between the Taonga and their kaitiaki, which is, I think, really beautiful. It talks about things like manaakitanga being the value or the principle that will ensure everybody's interests are captured. So don't fear the rest of New Zealand, because manaakitanga will ensure that your interests are also considered. But I think most importantly, and I'll finish on this, the Te Aki Taonga model also speaks to the Crown, and it talks about the Crown as a treaty partner, and what the Crown's role is, both in sort of implementing Te Aki Taonga and supporting it. So it says the Crown as a treaty partner has to support our rights as Māori, our rights of tino rangatiratanga, that its obligation as a treaty partner means that it has to not assert proprietary interests in our taonga, which is huge from an intellectual property perspective, and also that they need to look internally at the way that their own agencies deal with both our taonga and our mātauranga Māori, and ensure that those are either divested back to the true kaitiaki, or that they are acting in a way that's consistent with Te Aki Taonga. So that's a very quick little whirlwind through the Y262 claim and the Te Aki Taonga model. So I'm not sure if there's time for questions, but that's my kōrero for today. Kia ora.
Tēnā koe, Kiri. I hope that there will be some comments and some pātai that come through the chat. Engari, me pēhea te pātai, ngā pātai, tēnei wā poto. Nā reira, he mihi kauana ki a koe. He kairaranga koe, he kaiwhakairo koe, i te hinengaro, i ngā whakatupuranga. You're a weaver, a carver of the mind, of knowledge. You're a gatherer, and you are also a weaver of generations. So your lived experience of being an uri, of going to hui with your karaua, of your nannies, and it enables you to be the kaipupuru of the role that you have, a carrier of the work that you do. So we acknowledge you. We acknowledge your nannies and your kokos. They've done a great job. And we acknowledge the journey ahead for this claim and for the mahi of te tiaki i ngā taonga. Nā reira e kiri, I also see that there are other whānau like Linnell, who's online today this afternoon. We acknowledge all of you who have this technical expertise, but also the heart to support our whānau. Nā reira, tēnei te mihi ki a koe, tēnā rawa atu koe.